The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome, everybody. My name is Troy Baker, the director of the Better Business Bureau Serving Western Michigan Educational Foundation. Thank you for joining us. It is now noon. We are going to give it just a couple more minutes because I see a number of attendees are popping in. So I will give everybody a minute or two just to get logged in, and then we will begin. Thank you for your patience and thanks for joining us. All right, everybody, it's about 12:03, so we're going to get started here. Again, my name is Troy Baker. I'm the director of the Better Business Bureau Serving Western Michigan Educational Foundation. I want to thank you for joining us today for this webinar talking about the rules surrounding marketing your business and doing so with trust and ethics. We're pleased to be joined and do this in partnership with Mel Leonard, the manager of the BBB Serving Eastern Michigan Educational Foundation, along with Maris Snell, an attorney for the Federal Trade Commission, and Catherine Bennett, an assistant attorney general with the Michigan Attorney General's office. They've got a lot of great information for us today on what businesses really need to know when it comes to marketing their business and dealing with consumers. So before we get too far in, a little housekeeping. Everybody is muted. So if you do have questions, and the questions you have, please type them into that questions box there on the panel. We will moderate those and ask those questions at the end. This is being recorded. We will share this out with you following the conclusion of this. The email will probably go out tomorrow, along with have it online on our YouTube channel for anybody who wasn't able to make today. So with that, I will hand things off, starting with Maris Snell from the Federal Trade Commission.
Great, thank you. And again, for everyone, my name is Maris Snell, and I am an attorney with the Federal Trade Commission. And I am here today to talk with you about our endorsement guides and also our views on customer reviews. And before we get started, I do have to say that although my discussion today is based on our publicly available guidance on these topics, these are my views on the subject and not necessarily those of the commission or any particular commissioner. And with that said, we can get started. So let's see. To the next slide, or there we go. So Section 5 of the FTC Act prohibits unfair or deceptive acts or practices in or affecting commerce. And this is the key statute that governs any sort of deceptive or unfair endorsements and testimonials. And we will talk through some of the key examples of what constitutes deceptive and unfair endorsements or testimonials today. So probably the best thing to get a general understanding, there is a page on our website which is www.ftc.gov, and then that's slash business-guidance/resources, and there you can find a bunch more information discussing the ins and outs of these rules, and then also the guides themselves. And really what the basic purpose of these guides is to give instructions on how to accomplish truth in advertising and ensure that endorsements are honest and not misleading. So we develop these guides to give some insight on particular situations that may arise and things to look out for to keep yourself advertising truthfully, especially when making endorsements. So I guess the first thing we want to know is, what is an endorsement? An endorsement is when an individual is giving an advertisement of some sort and speaking about a product or service on behalf of an advertiser, usually the company that sells that product or service. And the advertiser is in exchange for the advertisement is paying or giving something else of value to the individual that's publishing the advertisement. And when we say something of value, this is interpreted broadly, so it's not always a monetary payment. That could be a free product. It could even be receiving a product before it's released, anything that is a benefit to you. So we watch this closely, as you could imagine, and many of you have probably seen. Social media has really spurred a lot of this type of endorsement activity from people who are reviewing products and talking about the products they like online. So the FTC does watch this pretty closely. An example is that just this past year, we sent out a notice of penalty offenses to more than 700 companies. And what this is sort of a letter notifying these companies of the main issues they may run into with endorsements and what they need to watch out for. And after receiving that letter, if they still violate these key principles, then they can be on the hook for over $43,000 per violation. So below are the 7 key principles that we set out in that letter, and we will go over those in more detail today. But just quickly, they are failing to adequately disclose a connection between an endorser and the seller of an advertised product or service, falsely claiming or implying that a third party has endorsed a product or its performance, misrepresenting an endorser as an actual user or current user or a recent user of a product or service, continuing to advertise an endorsement unless the advertiser has good reason to believe that the endorser continues to subscribe to the views presented in the endorsement, misrepresenting that an endorsement represents the experience, views, or opinions of users of the product, using testimonials to make unsubstantiated or otherwise deceptive performance claims, even if such testimonials are genuine, and finally, misrepresenting through the use of testimonials that the experience described by endorsers represents the typical or ordinary experience of users of the product or service. So the first item, which most people these days are probably familiar with, even if they don't know it, is the required disclosure when someone is endorsing a product. And now this explains the hashtag ad that you see a lot of the time on Instagram and other platforms nowadays. This is due to our requirement that you make a clear and conspicuous disclosure of material connections that might affect the weight or credibility that consumers give an endorsement. The connection could be a business relationship, a family relationship, a monetary payment, or a gift of a free product or something else of value, like we said earlier. So the disclosure of this relationship needs to be clear to those who are viewing the advertisement or endorsement. And what is clear and conspicuous depends kind of on the medium of the advertisement. So if you think of a YouTube video where someone's talking about a product, and it's in the background of the video, it means you need to leave the disclosure text, whatever you choose to do. It needs to be on the screen in the video for an amount of time that someone actually could see the words pop up. It can't just flicker for 1 second. That's not clear enough to meet the requirement. And similarly, if you stamp it onto your photo, you want the font to be large enough and in a color that is clear. It can't be tiny black font on a black background in a photo. That's not clear. People can't see that well enough. So it depends on the circumstances, but you just want it to be easily seen. And here up next is actually a case that gives a good example of this. The circumstances of this case, Warner Brothers case, was that Warner Brothers was coming out with a new video game, and they contacted a bunch of YouTube influencers who were in the video game realm, and they hired these individuals. They gave them an early release of the video game so they could play it and then create videos they would post on YouTube giving a favorable review. And then, so not only were they giving these YouTubers a free copy of the video game, they also were compensating them hundreds, if not thousands of dollars. So Warner Brothers did give some sort of general advice to these YouTubers about the disclosure they needed to be making, but the focus really was on what needed to be said about the product and the favorable things. Very little guidance was given as to the actual required disclaimer of the business relationship that was taking place. So you can see this screenshot from one of the YouTube videos in this case where there's, it's a little hard to see, but there's nothing about the relationship that is actually visible on the main description page. You can see at the bottom, there's that show more link that was clicked on. And then you can see way at the bottom, finally buried pretty much, it says this video is sponsored by Warner Brothers. And then even underneath that, it says, no one reads this far into the description. What are you doing snooping around? So this may have been, just one influencer who went astray, but this, was pretty common across the board that it was sort of a buried disclosure, and that type of thing where you have to click a separate button to go find it and it's buried in text is not sufficient. So up next is the next principle is not falsely claiming third-party endorsement. So what this basically means is you can't falsely claim that someone used and likes your product if that's not true. And so here's another case we had. These ads may look familiar. I know they did to me when I saw them. This was a company, Tar Inc., that it was selling health products, weight loss products, and what they did was create these websites that were designed to look like they were real news websites, when in fact they were just websites created by themselves to run these advertisements that looked like news articles. And they routinely would kind of frame it as if a certain celebrity was using the product and it had worked very well for them. So in this example is Paula Deen, and the title says how Paula dropped 30 pounds in 4 weeks, when in fact it turns out that Paula certainly hadn't endorsed this product, probably never used it. So all of this entire advertisement was just false. And so that is something you cannot do. So moving to the next slide like we said, you need to use endorsers who actually use your product. So that is important. The person endorsing the product needs to be an actual and recent user of the product. And this is probably one of the reasons you see those disclosures too on TV, where there's actually an actor who is reenacting a favorable review that someone has made of the product. They're accurately disclosing that in fact the person on the commercial isn't really the person who used the product and liked it, but it is a true review, so that's okay. They're disclosing that that's not the actual person, but the words are true. And then also you need to keep in mind that you can only keep running the advertisements as long as you have good reason to believe that the endorser continues to hold the views they are saying in the endorsement. So, for example, if your product changes significantly or a new competing product comes out that's much better, you need to kind of revisit with your endorsers to make sure that they still feel the same way about the product that they did when they made the endorsement, because if it's no longer true, then you can't keep running it. It's no longer accurate or honest. And sort of an even more nuanced take on this is that the endorsement not only shouldn't misrepresent the views or opinions of the person who's endorsing it, but also if the endorser has an unusually good experience, it's oftentimes not accurate to run that endorsement unless their experience was pretty typical. So that means you most commonly see this in the I lost 50 pounds in 6 months with this weight loss product. And so if that's not a typical, if most people are only going to lose 10 pounds in 6 months, you can't run that advertisement or testimonial unless you give a really clear disclosure, not only just results not typical, but you actually usually need to actually say what is typical, because otherwise people's minds kind of latch on to the really good result. And so it still kind of ends up having a misleading result. So you have to be careful with publishing the really best experiences that people have with your product. Let's see. And so here's an old but classic example of kind of misrepresenting the typical experience. Now this was an R.J. Reynolds tobacco case back in 1950 that we had against them, and their key advertising strategy at that time was running lots and lots of testimonials. So here is an example of one. I choose camels for their mildness. They're never harsh and have such a good rich taste. When the pace I go gets me fatigued, a camel gives me a lift. And that's from supposedly Miss Helen Stansbury, then the director of women's traffic for United Airlines. And here's another example of an ad on the right. And what the case kind of concluded was that all of these positive things, there were other ads that were talking about, it would increase your digestion and it would give you a calming effect. But there was never any sort of disclosure that these effects would be different depending on how many cigarettes you were smoking, or if you had health conditions. There was none of that back at that time. So it was giving the overall impression with all these favorable testimonials that in general, an average person would benefit from smoking. So that, that became a problem and resulted in this lawsuit and really kind of changed the game for these type of advertisements going forward. So to sort of conclude, here are just a few little tips on the influencer aspect before we get into a little bit of customer review discussion, but just make sure that you're not conveying claims via influencers and endorsers that you can't substantiate. Educate your influencers to clearly and conspicuously disclose their affiliation. Make sure you monitor them because what they're doing wrong is, can come back to bite you. And if they are doing things that are wrong, cut them loose, end the relationship, because it's not worth the risk. And so then lastly, we will quickly just touch on customer reviews, which a lot of the customer review things to keep in mind are relate to the same principles we've already discussed about where if there is a connection between the person making the review and the seller, that needs to be disclosed because otherwise those reviews will give a misleading impact on the people that are reading it. They, think it's an unbiased review, and in fact, there is something behind it. So here is an example of a pretty recent case. It was a skincare brand, Sunday Riley, and it came out that there's this email on the right side where a person at the company management is instructing the employees to create accounts, go on Sephora.com, and give favorable reviews for the products. And so this was really broad scale. The company itself was basically kind of manipulating the reviews for their products and inflating favorable reviews. So that was a problem, and we had a case against them, and we corrected it. But this is just a quick example of some of the reviews. But of course, they were all extremely favorable 5-star reviews. But in fact, these were created by employees of the company. And so similarly, you can't, just like you can't create fake positive reviews, you also should not be suppressing the negative reviews. And so here is another example of a very recent case against the fashion brand Fashion Nova that we had, where it became apparent that Fashion Nova had somehow been restricting any reviews under 5 stars on its website. So it was getting basically perfect reviews. So that was kind of a new variation of the review issue, and that's not acceptable. You need to be fair in publishing the reviews. So there's a Consumer Review Fairness Act, and that goes over some of the things to keep in mind with reviews. So it's illegal to include a contract provision that restricts the consumer's ability to review the products, services, or conduct. It's illegal to impose a penalty or a fee against someone who gives a review. And then it is okay to remove a review that contains confidential or private information, or it's completely false or abusive. So, if someone is saying something that couldn't physically happen with your product, or is using slurs or offensive language in the review, you can remove those. But it can't be motivated by just disagreeing with the opinion. It needs to be because it's actually there's an issue with kind of the content itself. And then just lastly, this is an example of a recent case we had where there was a contract provision where it says customer agrees not to file any complaints with the Better Business Bureau and agrees to attempt to resolve their complaints by contacting the company. So this is a clear example of something you should not do. You can't impede customers from publicly stating their opinion on the product or service, because that sways the public opinion and the accurate information isn't getting out. And so just to conclude, if there's more information on these subjects at business.ftc.gov, so check there, and I'm sure we'll have time for questions at the end. But that is all I have for now.
Fantastic. Thank you, Maris. I appreciate it. All right, we are going to now move to the Attorney General's office and Catherine.
Good afternoon, everyone. I am Catherine Bennett from the Michigan Department of Attorney General. I serve in the Consumer and Healthcare section in the Corporate Oversight Division. And I will be speaking to you today regarding the Michigan Consumer Protection Act. But first, I have to say that statements made in this presentation are not my own, or are my own, but they are not intended to reflect the views, opinions, or positions of the Michigan Attorney General or the Michigan Department of Attorney General. So the Michigan Consumer Protection Act is also known as the MCPA, and it's found in the Michigan compiled laws, and that law is primarily enforced by the Michigan Department of Attorney General. I'm not going to be able to cover all aspects of the law today, but I'm going to focus on issues frequently encountered by our office. So the law regulates trade or commerce. A key part of the definition is that trade or commerce involves goods, property, or service primarily for personal, family, or household purposes. The law provides a list of what's included. It includes advertising, solicitation, offering for sale or rent, sale, lease, or distribution of a service or property, tangible or intangible, real, personal, or mixed, or any other article or a business opportunity. It does not include the purchase or sale of a franchise. And specifically, the law outlines certain unlawful business practices when it comes to trade and commerce. It provides a list of unfair, unconscionable, or deceptive methods, acts, or practices in the conduct of trade or commerce. I'm going to talk about just a few of those today. First up, two practices involve business representing that it is approved or accredited, or that it has certain sponsorship, approval, affiliation, connections that it does not have. Better Business Bureau is sponsoring this discussion today, and for example, a business should not advertise that it has an A+ BBB rating if that is not the case. This is something me and my colleagues see a lot of. For example, in one case, I received a complaint or became aware of a complaint that a business had a symbol on its website indicating it was an accredited laboratory. It had a special accreditation when that was not the case. But this would really, goes across the board with various types of symbols showing sponsorship, approval, or certification. It's unlawful to advertise that way if that's not the case. On a related note, customer reviews. This is something Maris spoke about, so I'm not going to spend a lot of time on it, but that is also a concern under state law as well. For these particular reviews I'm showing right now, I can't speak to whether or not they are indeed true reviews. However, I can say that that this particular business had all 5-star reviews like this on their website. At the same time, third-party providers of reviews such as BBB's website, Google, and Yelp, or websites like that had negative, primarily all negative reviews. And so it is unlawful to provide false reviews, false all 5-star reviews in advertisements. Another one that we see a lot of, using deceptive representations or designations of geographic origin. This is when a business advertises that its products are designed or manufactured in the United States when really they come from elsewhere. We see this a lot with like drop shipping, where the company is purchasing goods from overseas and having it shipped directly from overseas to consumers. I have an example here from one of my cases where the website was suggesting that all of its products were made in-house in the USA. And if that is not the case, then the business should not be advertising in that way. So, focusing on businesses selling online, which obviously is pretty much most businesses nowadays, I would think. It's very important that if you're going to advertise goods online for sale, that you actually intend to dispose of them as advertised, or that you actually intend to provide them promptly or at a specified time, if that's what's being advertised. So, for example, if a merchant is advertising goods online, it states that they'll be shipped within 48 hours, but the merchant doesn't have that particular good in stock, so it's going to actually take a lot longer to obtain the good and then ship it out. That merchant would know or have reason to know that it's not actually going to be shipped out within 48 hours. So that would be an unlawful practice under the MCPA. Now, I've been talking a lot about businesses' websites, and I just want to make clear that this applies to advertisements and representations across the board. And of course, in today's day and age, a lot of that comes from social media. So the law applies to advertisements and representations made on Facebook, Twitter, Instagram, etc. This is an example of an Instagram ad that a business had for a particular product. And you'll see here some consumers making complaints kind of consistent with my previous slide, which is, you know, I purchased something from this business, but I haven't been sent them timely. I've never heard back from them. And so again, that's why it's very important not to advertise that something's going to be distributed promptly if that's not the case. In regards to returns and refunds, the law prohibits causing a probability of confusion or of misunderstanding as to the legal rights, obligations, or remedies of a party to a transaction. So you don't want to confuse consumers about their rights in regards to returns and refunds. It also requires a business to provide a refund when a transaction is rescinded, canceled, or otherwise terminated in accordance with the terms of the agreement. And I have a couple examples of that here. So here's a business website that provides a pretty explicit return policy. So if the consumer abides by this return policy and making the return, then the business must follow that the terms of the advertisement here regarding the return and refund or exchange. Similarly, from that same website is a business providing a 1-year warranty. So once the business makes a representation regarding the warranty and agrees that it will replace or exchange a product, again, it would be unlawful for the business not to abide by the advertisement or representation regarding this warranty. And next, I want to talk about grossly excessive pricing. So this is also a lot of times referred to as price gouging. It's unlawful under the MCPA to charge the consumer a price that is grossly in excess of the price at which similar property or services are sold. And here I have an example that came up during the beginning of the COVID pandemic, where a consumer complained to our office that a business was selling an R95 face mask for $108 per mask. And the response from the business was, well, we're not actually selling it at that price. It's just what we're advertising the price to be on our website. And it was pointed out by our office that simply making the offer manifests the intention to violate the MCPA. So just having it listed at that excessive price is unlawful. Kind of related to that is the provision against causing coercion and duress as a result of the time and nature of a sales presentation. That is also an unlawful business practice. And I have another example here from early on in the COVID pandemic. This was a business advertisement regarding masks, and noting there's a national emergency, suggesting that they may be forced to ship the masks overseas, so they're not going to be available to the public in Michigan. Suggesting you got to protect yourself. It's dangerous times. Everybody else is reportedly sold out. You're not going to be able to protect yourself. This was an example of causing coercion or duress at the time of the sales presentation. So that again is not a full list of the various unlawful business practices under the MCPA. Those are some that we see a lot of. Now I'm going to talk a little bit about the Attorney General's role. We receive complaints from consumers regarding alleged violations of the Act. A lot of times we do consult with Better Business Bureau. They oftentimes get in touch with us if they're receiving a lot of complaints that could implicate the MCPA. And so the Attorney General has a couple of different options once it becomes aware of consumer complaints. One option is to initiate an investigation, a formal investigation. In that situation, the Attorney General, if the Attorney General has probable cause to believe a person has engaged, is engaging, or is about to engage in an unlawful method, act, or practice under the MCPA, the Attorney General can seek ex parte subpoenas from a court to investigate the company. By the term ex parte, I mean the company wouldn't have the opportunity to be heard in front of the court or have notice of that. The Attorney General can go straight to the court without informing the business to get these subpoenas. The subpoenas could request documents from the business, or could seek to take investigative testimony, similar to a deposition of business representatives or from people who have knowledge of the business practices. So that's one option the Attorney General has. Now, if the Attorney General decides it's going to take some sort of legal action, such as file a lawsuit against the business as a result of the business practices, the Attorney General is required to provide notice not less than 10 days before the commencement of an action. And that's to give the person an opportunity to cease and desist from the unlawful practices. And that notice is typically sent by mail, postage prepaid to usual place of business, or if they don't have a usual place of business, the last known address. Of course, for corporations, it would be sent to the resident agent designated to receive service of process. This next slide is an example of one such notice that I sent to a business this past December. Of course, it was the holiday shopping season, and we had received and became aware of various complaints that a business was taking orders for toys and not mailing them out to people who had purchased them from the business online. This is not, of course, a complete notice, but just a part of it to show you kind of what that might look like. But basically, it is intended to give the notice required under the law and allow the business to immediately cease and desist from engaging in the unlawful business practices. And the unlawful business practices are then described in the notice. So if the Attorney General does decide that litigation is appropriate, after providing that notice, the Attorney General can file a lawsuit under the MCPA. Under Section 5, MCL 445.9051, the Attorney General, once there's probable cause to believe that the person has engaged, is engaging, or is about to engage in an unlawful business practice, the Attorney General can bring a motion or an action for injunctive relief. So basically that means that it is an action to stop the business from engaging in that unlawful activity. Such a lawsuit can be brought in the county where the defendant is established or conducts business, or if the defendant's not established in the state, in the Circuit Court of Ingham County. Separately, the Attorney General can also bring a class action on behalf of consumers residing in Michigan or injured in Michigan. And that class action can seek actual damages, so actual monetary relief for consumers who have been harmed by the business practices. And so with that, that's all I have to say today, but I am happy to take questions when we get to that part of the webinar, and I thank you for your time.
Thank you, Catherine. I am now going to hand it over to Mel Leonard, manager of the BBB Educational Foundation for Eastern Michigan.
Good afternoon, everyone. This is Mel Leonard at BBB Eastern. Today, I'd like to talk about the program that the Better Business Bureau has in place called the BBB Dispute Resolution, excuse me. The Better Business Bureau does offer a resolution program for what most people call complaints. We can utilize this, and you can find it. Most consumers will call first, but you can find it on our dashboard on our website at bbb.org. As you're looking at the screen, there's a square on your left-hand lower corner that says file a complaint. When you go to our dashboard, that square right there is what you will click to go into our complaint application. Now, if you do not have access to a computer, we also can have a complaint package sent out to you through the mail. All you have to do is call the appropriate Better Business Bureau. Remember, we do have 2 Better Business Bureau offices here in Michigan. On the western side of the state is BBB Western. On the east side of the state is BBB Eastern. The BBB Eastern also covers the Upper Peninsula. So whatever region you are in, you can contact the appropriate BBB. Okay, all right, excuse me. My slides were not in the order I sent them, but no problem. I just want to talk about the complaint process in a simple form. All complaints that come into us, whether they are online or if they are sent through the mail, they must be in writing. We never take a verbal complaint. All complaints must be in writing. Those complaints are verified and vetted. That's from the consumer standpoint. We will verify the consumer, but we'll also verify the business and what the complaint is about. We make sure that we have all the information needed for the complaint, and then we proceed to go ahead and contact the business for a response to this complaint. The complaint that is sent to the business, all businesses have a right to give us a response. All accredited businesses must respond to the Better Business Bureau. This is part of our best business practices, and it is a part of our agreement as a standard of trust for accreditation with the Better Business Bureau. If we are dealing with a non-accredited business, we would hope that they would respond. We will give them 2 opportunities to respond to us, usually within a 7-day period, depending on whether it's online or through the mail, but we will give them adequate time to respond to a complaint. Complaints and responses can be published, and the reason why we say can be, sometimes they are not published due to the nature of the complaint or the information that's provided to us in the complaint, whether it's private information or personal information. We will never publish that type of information online. However, a complaint and response can be published. Just want to briefly talk about the 3 major dispute resolution options that we have. Every complaint that comes in, it goes through a conciliation phase. That is where our staff here in the office will accommodate the consumer and the business to help them resolve their dispute. Usually this will occur either by telephone or by email or mail. And many times we can settle these disputes simply and quickly. However, there are times when the consumer and the business may need a little mediation. Again, we have a trained mediator in the office that will help them come to a resolution. Many times, due to frustrations or whatever, they can't reach a settlement. they need someone to come in and mediate. We offer that information and we offer that assistance. Lastly, we have arbitration. And of course, arbitration means that we will bring in a professional, usually an attorney or a retired attorney. There may be a fee involved. However, this arbitrator will come in based on the agreement between the business and the consumer, an agreement that they will pay the fee and will also accept the decision of the arbitrator. We can have an arbitration come in, the arbitrator will listen to both sides, and then they will make an impartial third-party decision. This is a binding agreement, and the consumer and the business agree to that effect. So those are the options that are available in our dispute resolution program. Again, any complaint can be filed online on our bbb.org. Thank you. Troy?
Thank you, Mel. And yeah, so we wanted to show a little bit about what the BBB's process is to resolve some of these issues that come in, both as complaints, and then we do see reviews as well. One of the things that I always tell businesses is, the customer is not always right, but they are always the customer. And at the end of the day, you want them to be your customer. So when you're responding to issues that come up, when you're talking about marketing your business, talking about what you're putting out there, you want to be honest and trustworthy about how that works and what you are doing. So from a standpoint of why is this all important? Well, when it comes to trust, most consumers are coming to you with distrust. They don't believe what's going on until you prove it to them. So when it talks about your marketing, when you talk about the things that you are putting out there, Maris and Catherine talked about the legal side of it. You also need to consider the practical side of it. Is what you're doing really going to build that trust and have that customer not only come to you now, but keep coming back to you? So when it comes to complaints, and Mel talked a little bit about complaints, they aren't necessarily a bad thing. In fact, in many cases, they are an opportunity for your business. Never respond while angry is a great thing. Take a breath. We want you to respond to all of the reviews and all the complaints. It is a great thing to do. But examine how the situation was handled and think, what would you want to happen if you were that customer? How would you want to be treated in that case? Don't be afraid to apologize if you did something wrong. Work to make sure you're making it right, and be honest and show how you're resolving that issue. That's why I say complaints are not always a bad thing, because it gives you an opportunity to demonstrate exactly what you're going to do for the next customer. And when I see one or two complaints, I look at it as an opportunity for me as a consumer to say, okay, well, I hope nothing goes wrong, but if it does, this is how they're going to take care of me. And that's really the important thing to demonstrate when you respond to reviews and complaints, because this really is that opportunity for you to show every other customer out there what you are going to be doing for them. And then if possible, end with an offer to discuss the issue with the customer. People like to know that you're willing to reach out and talk to them and work it out. So those are a couple tips to do while you are working on resolving any issues that may come up, especially as it pertains to reviews and complaints. Above all, be honest, be kind, and think about those same responses that make you feel better as a customer. We have about 11, 12 minutes left here. I'd like to open it up to questions. Remember, if you have questions, you can type them into that question section there on your panel. Looking at what we have right now, one person writes, a major distributor has put our products on their website without permission and are blatantly lying about lead times and charging for a warranty that we provide for free. What do we do? Catherine or Maris, do you have any suggestions for this person?
So if it's a dispute between two businesses, that's not something that would generally be covered under our act. So the business would have to get a private attorney to represent them in that sort of dispute. Certainly, if consumers have complaints about the distributor's representations that are not accurate, then those could be directed to our office.
So it sounds like from a consumer standpoint, the consumer may have a cause of action if they're being deceived in some way. But from a business to business standpoint, this may be a legal issue between the two organizations.
Correct.
Thank you, Catherine. One question I wanted to ask, and to Maris and Catherine both, we see a lot of, it's not a I've walked into a store and the person, after negotiating a discount said, well, I'll give you 10% off, but you got to leave me a review. From a consumer standpoint and from a business standpoint, what should be put in that review to make sure we're complying? And I guess I'll focus this to Maris first to make sure we're complying and not doing something wrong.
Sure, yeah, that's a good question. Typically our advice is when you're not sure, disclose it. So I think my recommendation for that situation is even if it is a little bit of a gray area when you're not saying you need to give us a favorable review, it's just I'll give you something if you give a review, but still oftentimes maybe those reviews will be positive. So really just being on the safe side, I would say always disclose it in the review. Just say, you do see that a lot where people will say, I received this product for free in exchange for agreeing to give a review. And that's all you really need to do, just so people are aware that you did get something before you gave that review.
Yeah, it's kind of hard to stand in front of the salesperson and write a bad review right in front of them. So it probably is going to be a good review in that case.
Exactly.
Another question that came in, an elderly customer sent us an email giving a good review. Can we put that on our websites ourselves and credit them?
I would say that probably in that situation, it would be best to see if you can respond to the person who contacted you and make sure they're okay with using that. But in general, yes, as long as the person's okay with you publishing it, even if they didn't, go put it on your website themselves, that would be okay. If it's truthful, you don't want to alter the wording at all or anything. Make sure you're accurately representing what was said after you get permission. But yeah, that typically would be fine.
I know that raises a question of the fine line between encouraging positive reviews while, as you had spoke about, not suppressing negative reviews. So any advice for businesses on where that line is? Because I know a lot of businesses will want their happy customers to go give those 5-star reviews. So how do you encourage that in a way that doesn't get you in trouble?
Sure, yeah. Some of the things that it's typically not a problem, especially like you oftentimes see if like someone does painting work on your house or something, the project's completed and then maybe in the last email they tack in something like, we'd appreciate it if you gave us a review, and then they give you, a link or where you can find their website or their Facebook page, whatever it may be. That type of thing is totally acceptable because they're not asking for a particular review. They didn't do the work, in exchange for a review. You had a separate business relationship. They're just giving you a reminder, and that type of thing is perfectly fine. Once you start actually giving people things to get reviews, it does get a little more tricky, like we discussed. But it's always okay just to remind someone, you can review us on our page. a reminder is always going to be fine.
And going back to that, would there be an issue with, a lot of people have the apps that they use now to get reviews. Would it be an issue to send it to customers you know are happy and maybe not so much to customers you knew had a bad experience?
I think it's a little bit of a gray area, but it's true. If you don't know 100% really what that review is going to be and you're not requesting a particular result, you're probably okay on that because there's not really anything to disclose there. It's you still just sent it to a person and asked them to give a review if they wanted to. So it doesn't. I can't really imagine that we would expect someone to disclose, I thought this person would give me a positive review or anything like that. That is kind of stretching the bounds of what's expected of people. But I just be careful about, think through things and make sure, if there is a question, we always encourage you to disclose if you think there is something to disclose. But
as long as you're not specifically asking for that positive review, then.
Exactly. That's the way to be the safest. And when you're not giving anything, it's just really they're doing it voluntarily and they can really say what they want. And, unfortunately, sometimes people do surprise you there and you thought they would give a positive and sometimes they don't. So, it evens out that way. And that's why that is fine because they can just give an honest review.
Okay, we are down to the last couple minutes here. I guess I will open it back up to Catherine. Any final thoughts before we wrap up here?
Sure. So one thing that I did not mention in my presentation is that the typical process when we receive, our office directly receives complaints from consumers, is that we will forward them to the business for a response. Most of the time, things are resolved through that kind of informal process. So it's not that, we get one complaint from a consumer and we automatically jump to go into the court to initiate an investigation or to file a lawsuit. It's just important, though, that if a business does receive communication from our office, indicating that we received a complaint, it's really, really helpful for us if the business promptly responds to that, so that we can get a better understanding of each side of the dispute, and take it from there. And again, I just thank BBB for the invitation to be here today, and the opportunity to speak with all of you.
Maris, final thoughts?
Yeah, thank you for having me today. And really nothing beyond what I covered. And just, if you have concerns or you spot something, definitely our website has a lot of information and also a complaint portal. So, feel free to reach out if you see anything that you're worried about, but also to find resources for additional information.
Mel.
Thanks, Troy. Just want to say thank you to Maris and Catherine for being with us today. And again, you can reach us at bbb.org/Detroit for Eastern office. Thanks again today for participating. Troy.
Yeah. Thank you, Mel. I will echo that as well. bbb.org/Western Michigan. We'll get to the Western side. BBB.org is a great resource for everybody. Hopefully businesses will use that too. We will have this recorded webinar available on our YouTube page and in an email that will go out that will also include contact information as well. So an email will go out tomorrow regarding that. Thank you, everybody, for joining us. We appreciate you giving us your time. Hopefully you learned something. If you have further questions, you can reach out to the individuals at the contacts I will provide tomorrow. Everybody have a fantastic day.